Shall we start?
Yeah. Good morning, sir. You may start, sir.
Good morning, Ji. Can you hear me?
Yes, I can hear you fully, clearly.
No, the
I
Mr.
think
Goel, I don't know.
Goel Saab, I
Goel
think
is-
Madlapalli sir can start.
Yes, sir. You may start, sir. You are audible, sir, now.
I'm audible now. Shall I start?
Yes, sir. Yeah, you may start, sir.
Okay. Good morning to all the ladies and gentlemen. This is about your paper 4 lecture on the leading cases. And as you have seen from the record, we have given you in all 64 cases to study, and they are in different branches of law, namely the constitutional law, education law, criminal law, environmental law, which includes mining as well, commercial divisions, etc. And the service law as well. Now, in terms of your preparations, what we will expect is basically your understanding of the law on the basis of the facts of a given case and your application of mind. Now, once you have gone through the entire reading of these cases, you will also note that the reading may not be just limited to 64 cases. Your reading may be even beyond these 64 in as much as, for example, if you take the case of Judicial 2018 of the Constitution Bench. Now that basically refers to earlier two judgments, Nagaraj as well as Indra Sahane, and even to some extent Chinnaya's case. Now, this case was referred to the Constitution Bench basically on two issues. One was the applicability of the quantifiable data as well as the creamy layer concept. Now, this was on the background of both the judgments, Nagaraj as well as the Indra Sahane case judgment of the larger constitutional bench. Now, the judgment in Jarnail Singh in 2018 by the Constitution Bench basically framed issues which again quantifiable data was in two different modes. One was quantifiable data regarding backwardness, and second was quantifiable data of the cadre strength. And the third issue was regarding the creamy layer principle being made applicable even to the cases of promotions. As you know, this was from Article 16, 4, 5, amendments 4A. And Nagaraj decided the constitutional validity of these amendments, incorporating reservations in promotions as well, and further carrying forward the quota, which is to be filled in. And therefore, the Supreme Court, the last line, while deciding the constitutional validity in the last paragraph, also said that the doctrine of creamy layer will be applicable to promotions as well. Now, this was an issue which the Constitutional Bench therefore considered on the background of the Indra Sahane case regarding the quantifiable data and the creamy layer principle on the background of the Nagaraj judgment. Now, the Supreme Court held that, look, as far as the quantifiable data is concerned, the Indra Sahane judgment was very clear that as far as scheduled caste and scheduled tribes are concerned, the quantifiable data of backwardness does not apply. But however, the cadre strength will have to be examined because it's always subject to availability of the vacancies and all that. There must be a study on quantifiable data of the cadre strength. But the Supreme Court also came to the finding that the creamy layer principle will apply for promotions as well, despite the fact the uh, Indra Sane judgment was on different lines as far as this issue is concerned. But the Supreme Court has answered the issue of this creamy layer in a different way, said that constitutional courts are not debarred from uh, coming out with these requirements so far as the creamy layer concept is concerned, having regard to Article 335 of the Constitution, efficiency of administration and all that. And that is how now it is a subject matter of the government of India, how they will, because the before the three-judge bench also, this issue, the issues which were framed by the learned Attorney General were basically confined to the decision of the Supreme Court. And one of the issue was not this, as to how this is going to be implemented. Probably it is for the government of India to come out with different measures and how they are going to implement the government of India as well as the state government. What I was trying to tell you was that, look, the Jarnail Singh judgment as such makes you read the earlier judgments as well. So similarly, in all other cases also, it is not necessary that, for example, Antule's case. Now, Antule's case, there are three cases of Antule, 1984, 1988 and 1992. Now, we have given you case range of 1988 judgment of Antule's case. And there may be references to earlier judgments as well. Similarly, if you see this Sarda case, Sharad Sarda case, which is basically on the principle of circumstantial evidence and the chain of circumstances being complete without leaving any doubt that he and he alone or she alone is the accused who has committed the crime. That judgment refers to number of earlier judgments also. So you will have to at least familiarize yourself on the earlier judgments as well. For example, this Shivaji Bobde judgment of 1973, being often quoted by of late by the Supreme Court in deciding even the death cases based on circumstantial evidence. And para 19 therein, if you see that must and may, how the Supreme Court, Justice Krishnaiyer, who rendered the judgment, basically culled out that the test of evidence in criminal law is different from the test of evidence in civil law. And therefore, these judgments, on the face of it, you may not be, it may not be advisable for you to confine to only reading these judgments alone. If these judgments have referred to earlier cases in support of the ratio that they laid out, you will have to familiarize yourself even with the earlier cases. Now, when it comes to the ratio as such, kindly keep in mind that the ratio should be on the basis of the issues framed. In number of judgments, there are issues framed and then answered. And issues framed and answered, that becomes the ratio. But for example, in this judgment of Indore Development Authority, there are a number of issues framed and they have been rightly answered. But there are some other observations apart from these issues. Now, those will be basically, not the ratio as such, it will be only an arbiter. But you will have to sort of understand yourself what are the ratio has to be culled out on the basis of the issues framed by the Supreme Court on either on reference or otherwise. And therefore, this also you will have to keep in mind. Now, for example, in the constitutional law, one of the judgments you have been in the list provided is the judgment of Justice Nariman regarding the Speaker's action or the delay being caused in deciding the cases of disqualification. And therefore, if there is any inaction or delay caused, whether the writ court will have the powers to sort of entertain a writ petition and call upon the speaker or request the speaker to decide the cases. This was the judgment which is called as Kesham Singh versus the Speaker of Manipur Legislative Assembly. Now, in this judgment also, there are references to earlier judgments. And then that is how the Supreme Court, referring to its earlier judgments, also came to the conclusion that look, if the Speaker is not deciding the applications pending before him, it is not that the Supreme Court is or the High Court is devoid of powers to consider these cases expeditiously and give the decision whatever it may be in his opinion, the Speaker's opinion. If you see in para 31 of that judgment, there are some general observations made. Of course, it is for the Parliament to consider. But ultimately, the ratio in this is the scope of interference by the constitutional courts. If the Speaker doesn't take any action or he sits for the disqualification claims, then the courts can interfere. That is basic ratio. So in this manner, you will have to sort of examine all the case studies that you have been provided with and ultimately understand what is the ratio and in what context and how you make it applicable uh, for a case that you will be called upon to deal with. So your understanding of the law on the basis of the facts of that case is very important. All branches of law, whether it is civil, constitutional law, service law, criminal law, or environmental law, or the commercial law. So that is very important for you. And we have tried to give you enough choice available, and it should not be difficult for you to sort of select your own field of choice or the subject you are familiar with. And that, of course, my learned friend Mr. Ansaria will explain to you in detail. But and I am sure he has more experience than I have in this in these matters. So ultimately, he will be more of a guiding figure to you on going ahead with your preparations and how you write your examinations. But basically, I just wanted to explain to you that please keep in mind that your reading and understanding of law need not be limited, and you will have to expand your horizons of thinking, understanding, factual basics, applicability of law to different situations. And therefore, your preparations must be in the direction that you sort of get into much more details. And of course, you will have to be familiar with the language of the statute as well, because unless you have understood the language of the statute or the constitutional provision or any other act, you will not be able to understand and the ratio. And the ratio has to be considered and understood if you are aware of the facts and the provisions of law. That is how it goes. Even in commercial division, same principle will be applicable. In environmental laws, there are much more, public interest oriented issues as well. Similarly, in human rights law, it need not be sort of confined to, it is a very broad-based exposition in human rights law also. From each case, each situation, you may have a different exposition in the human rights law as well. And with this brief introduction, I pass it on to my learned friend, Mr. Vijay Hansadia. Thank you.
Thank you, Mr. Madlapalli, sir. Friends, good morning. And Mr. Madlapalli has explained to you that don't confine yourself to these case laws, broaden your horizon. And don't read it only for the purpose of answering the examination. If you know these 64 case laws, you know almost the entire branch of law. And in the Supreme Court, you know, we are in the Supreme Court. Supreme Court, you're not confined to a particular branch of law. For example, if you go in the trial courts, you have an income tax, you go to criminal side. But in Supreme Court, you are expected and you are required at least to have a basic principles of all branch of law. More importantly, the Constitution, and then CPC, CRPC, commercial cases, etc. All branch of law, you must familiarize yourself. And I get this opportunity to read and reread these judgments. You always find a new horizon, new line of thinking. And as Mr. Mandlapalli had told you that we have modified the list in a big way. Idea is that you must be updated. You will find in the list 64 cases last at least 15 to 20 cases are last up to 3 years. So just see the latest case laws and then go back. If you see the latest case laws, you will understand the earlier case laws also, earlier principles also. So let us start with one of the problems which now presently is facing is tribunalization. Now, how did the concept of tribunalization come soon? It was introduced by the Constitution 42nd Amendment Act by inserting Article 321A, 321B. Then the question arose whether these tribunals can take away the jurisdiction of the High Court. Earlier, SP Sampath Kumar in 1987 said, yes, it is a substitute of High Court. And if it is substitute of High Court, two things are very important. One, you must have an independent judiciary. The selection process is very important. And why did the tribunalization came for the first time in 1976 by the 42nd Amendment? Because it was found that the cases are delayed, it can be speeded up, and there are always specialties. For example, in tax, somebody who knows more tax, so it can be a technical member to take the specialties. You have service laws, you have experts in service law, you go there. So there are two twin purposes for creating the tribunals. One, speedy justice, another, specialization. And most important is that of both the things can be achieved only by an independent adjudicating authorities. If they are not independent, if they are subserved to the government, because it is ultimately in all these cases, other side is most of the time government, a concerned department. If that concerned department has the role or has the more say, then that is not an independent authority to adjudicate. So as I said, and as you must always compartmentalize these 64 cases in various headings. For example, under the heading of tribunal, you have 3 cases. One at serial number 9, L. Chandrakumar, one at serial number 55, Roger Matthew, and one at 64, Madras Bar Association. Just read them together. Don't read independently 1 to 64. Read 9, 55, and 64 together. They're all on tribunal. L. Chandrakumar said, overruled the earlier view and said that the High Court will have the power because High Court power is a part of basic structure, is part of judicial review, and you cannot take it away, that part of the judicial review by the High Court. So it reversed the earlier decision and now said, yes, tribunal would be there, administrative tribunal act are there, central administrative tribunals are there, and their order would be subject to judicial review by the High Court under Article 226, but it should be by division bench. Then question arose. In 2017, the central government made a uniform tribunals and appellate tribunal provisions. Question is, well, who will select them? Whether it's independent body. The provision was that the executive has a larger say. Supreme Court struck it down, said that the independence of judiciary is important. If you are taking away the power of the normal court and conferring on a tribunal, it should be on the same parameter. The confidence of the people should be same parameter, and they must be independent. And that's why they said there must be a selection cum search committee, which should be there and which must comprise of the Chief Justice of India as the head and other authorities, which will have a more say by the judiciary and not only of the executive. Dominant role would be of the judiciary. Because if you allow the High Court, and there is a provision for removal by the executive, that also Supreme Court said it is unconstitutional, because if it is an adjudicating body or authority which is deciding the cases, and if you give the power to the executive authority to remove them, it will be unconstitutional. It will affect the basic structure and independence of judiciary. So that's how it comes. Then again, The third round came in the Madras Bar Association because government again made some rules. National Tribunal Commission was constituted. There also the executive was given more power or has a dominant role. So then again, Supreme Court reiterated that you must have a National Tribunal Commission must comprise of making of selection and also of removal. The selection must be headed by the Chief Justice of India or a judge designated by the Chief Justice of India. And search committee, and then it will have the members from the search committee will have members from the law ministry, from the concerned department, and some other department of the secretaries of the concerned department. And the term is also very important to ensure independence of judiciary. It must be 5 years or 70 years, whichever is earlier. It also says that removal cannot be done by the government. They can have a preliminary inquiry, but ultimately the search committee has to do. So what I'm trying to highlight to you is what is the purpose? As Mr. Marlapalli said, you don't read it abstract. Read it on the facts. What are the relevant statutory provisions and what is the ratio? These are the three important ingredients of any case, any leading judgment. On what fact the case arose, what are the relevant statutory provisions, and what is the ratio, and try to go into the reasoning that will add your mark and that will help you in arguing before the court also. Don't, as I said, don't read it only from the perspective of examination. Read it from enlightening yourself, enlarging your horizon of knowledge, and that is how you will learn these cases. Then another important aspect is, again, as I said, that there are cases which are on the same subject, there are different. For example, under the IBC, in insolvency and bankruptcy code, there are two cases, 52 and 57. Read them together. Don't read independently because both are linked to each other. If you read these cases which are in the air, you will know what is insolvency and bankruptcy code, which is a very new development and highly required subject. There, the firstly is the corporate insolvency resolution process is there. There is a mechanism provided. Enlighten yourself. What is the mechanism? How it is to be done? There is a time limit given. And then in the insolvency resolution process, somebody is to start. There are two categories of creditors. Basically, what is insolvency proceeding? They're creditors, you are not able to pay, and then they come. Then that money is to be recovered. Then that's a resolution, a corporate insolvency resolution process. There are two categories of creditors. One is financial creditor, one is operational creditor. Now, who are financial creditor, who are operational creditor? You must know. Why there is a difference between the two sets of creditors? You must know. And whether anybody has a preferential right or other has a lesser right, you must know. You must also know that there is a time limit given for resolution, insolvency resolution, dispute resolution process. A statute gives a 330 days, but whether it is absolute, whether that can be extended, if yes, on what principle, at what point of time it can be extended, enlighten yourself, and you will know a lot of things. I have read at least 5 times to talk to you, and that has given me, every time I read, I get a new idea about it, and that you can use it while arguing a cases of a similar nature of and other things. And then as Mr. Madlapalli has said, that land acquisition cases are there, that Indore Development Authority case is there at page serial number 63, which is a very important and it decides so many questions of law. So go to what was the Land Acquisition Act earlier, 1874, how it came to be replaced by the 2013 Act, Right to Fair Compensation Act, and thereafter, what are the gray areas which developed? One of the things was whether it will lapse, under what circumstances it will lapse, under what circumstances it will not lapse. And I suppose it says if you don't take position or if you don't make compensation within a particular time limit, it will lapse. Then again, there are so many riders. So just acquaint yourself, first read this section. Section 24 is there that is the Indore Development Authority. Read this section and read the interpretation of that section given by the Constitution Bench in that case. And facts are concerned, it is very important. For example, in the right to information is a very important right which is given to all the parties, which are given to the citizens for the first time, according to me, that citizens are given the power to compel the executive that you have to give me within this particular time. Now, what are those informations which are there? all the public authorities are required to disclose all the information in its possession. There is only an exception, Section 8, certain exceptions which cannot be given. So read what are the provisions of the section, what are the facts of the case at serial number 56 that was required. There were 3 or 4 or 5 things perhaps. One was whether the selection mechanism which is given for the appointment of judges there is a correspondence between the executive and the judiciary, between the Chief Justice of the High Court, within the Chief Justice of the Supreme Court, whether that should be disclosed in public interest, whether assets of the judges are to be disclosed. So the courts said, yes, you must disclose everything except those comes under Section 8. Under Section 8, there are 2 categories. They're largely in public interest, larger public interest, for example, friendly relations with foreign state, defense affairs. Their knowledge, the public authorities know, but that cannot be disclosed. There's a complete bar. Another bar is between the fiduciary relationship. Somebody has given, an employee has given some information to you, whether you can disclose, because it affects the right to, you may know it, but it affects the other person's right to privacy. For example, in the selection process, so many things are given. His income is given. His personal details are given. His marks are given, which his medical records are given. That may not be necessary for you, necessary for the public to know, because there again, it affects the confidentiality. And as you know, that the right to privacy has now been recognized as a constitutional right. It flows from Article 21, and it has been said it is an inherent, inalienable right. You cannot alienate it, and does not depend only on the constitutional provision. For example, Article 21, we have right to life and liberty. Does it mean, suppose the Constitution did not have Article 21, does it mean that there is no right to life? There are certain rights which are inherent in a human being. You are a human being, right to dignity, right to privacy. The Supreme Court has said, even if it flows from 21, but these are inalienable rights, they are human rights. And so don't compare it with that only Article 21 has given. There are certain things which are very basic. So right to privacy is a basic. So if you ask for certain details of the persons in the correspondence held between the Chief Justice and the High Court, of the Chief Justice of the Supreme Court, the government of the state or the central government, you may get it. But whether it will affect the right of privacy of the other person, you have to take into account that aspect of the matter. So, but wherever there's a larger public interest involved, that prevails. So there the Supreme Court has said, yes, all these informations may not be given, but so far the assets are concerned, there's a larger public interest involved of the judges. Give the asset. There was a dispute as to whether the Supreme Court itself said, yes, the assets of the judges may not be given. That is how the question arose with the Chief Information Officer, then went to Delhi High Court and then to Supreme Court. Supreme Court ultimately said the details of the assets is to be given. The deliberation of the collegium is not to be given. What information they have, what input they got may not be given, but it affects the third person. It affects the candidate. Suppose you are considered as for elevation of the High Court judge. Whether you would like your share, your income, whether you would like to share the health, you would like to share your personal likings and dislikings, you may not. It affects the candidate, the third person. So you cannot give those information, but which are in larger public, after you are appointed, larger public interest requires that the assets and the income of the judge who has been appointed on the Constitutional Court must be available in the public domain. So you can get all these things on the website. You get it also on the website, the decision taken by the collegium, but not the inputs, not the discussions, not those things. Then, of course, there is no question answer session. Otherwise, in a physical hearing, we have question answer. So we have so many things to discuss it. We'll love to have the questions from you. Another important, as I said, that in the right to privacy, there are 2 judgments on right to privacy, which are in the list of 64 cases. One is that's Puttaswamy 1 at serial number 43. Another is Puttaswamy 2, serial number 48. Read them. This is very, very informative. A new jurisprudence has developed out of that. Read in the context of the facts. Now, again, the 9 judges laid down the principle that the right to privacy is an inherent human right. It flows from Article 21. It also an important right because such rights have been recognized internationally by international conventions to which India is a signatory. And Article 51 of the Constitution says, though it's a directive principles, it says that yes, one of the directive principles you must try to achieve those those international conventions where India is a signatory. Having held that, you must come to the specifics. What are the challenges in that case? The challenge in that case was regarding the Aadhaar, whether the Aadhaar Act, that is Unique Identification Authority, under which Unique Identification Authority of India constituted, affects the right to privacy. It takes certain biometrics of yours. It gives the face recognition of yours. And then Aadhaar is prepared. Whether it affects the right to privacy. To some effect, you can say it is available to some of the persons, to the authorities, to the authority under the Act. They have your biometrics, they have your face recognition. But what is the purpose to be achieved? The Supreme Court laid down 3 tests which must pass, which can invade the right to privacy, or which is an exception. I will not call it an invade, which is an exception to right to privacy. One is it must be based on a law made by legislature. And in that case, there is an act, Aadhaar Act is there. So the test of Aadhaar was upheld that it will come. Second is, there must be a legitimate state aim. Government must have particular purpose for framing that. It cannot be as general surveillance. That all right, we want to have surveillance over all the citizens of the country. It's not possible. There is no legitimate state aim. And the third is proportionality. So we must know there are 3 tests which must pass to uphold any law for the purpose of carving out exception to right to privacy. If all these 3 tests, they are not cumulative, they're all cumulative, they're not and or. If all the 3 tests passes, then only you can have a law which can affect to some extent your privacy. Now, Aadhaar Act was challenged, saying that it violates my right to privacy. You have my biometrics, you have my face recognition and other details, my residence address, etc., etc. But the Supreme Court upheld it, saying that the reason for upholding Aadhaar Act is that there is a large scale of public distribution, there is a large scale of social benefits which are given, and pilferage is stopped by that process. It goes directly to the person. It cannot be that third person can come and claim it, which has been happening earlier. So Supreme Court found it a justification for Aadhaar because it helps in distribution of the state subsidiaries, distribution of the state benefits, social welfare legislation reaches to the person for whom it is meant. However, 2 other cases where they say it is not permissible. For example, the mandatory linking of it with the bank account, though many of us has given the details, but it is not mandatory. It cannot be, a bank cannot ask as a mandatory condition that you must give me Aadhaar details. I must upload the Aadhaar on my bank statement, then only I will open an account. The Supreme Court in categorical terms says the theory of proportionality, because the banking and your when you go to the bank, you give your particulars, you give your biometrics, you give your not biometrics, you give your all the details, your PAN number, your identification, your address proof. Thereafter, Aadhaar is not necessary. Similarly, for mobile connection, many of the mobile companies ask Aadhaar, but it is not mandatory. They cannot ask you that you must give Aadhaar, then only will give you connection. It is optional. These 2 things have been carved out as an exception. In that case, saying that Aadhaar, that the right to privacy may be affected because it does not meet the twin test of existence of law as legitimate state aim and a proportionality theory. So far as these 2 are concerned, these are not permissible to have a necessary linkage with Aadhaar. Then there are cases of criminal law. Mr. Madlapalli said that you must read all branches of law, which includes criminal law. Now you must know, when there is a Supreme Court Constitution Bench judgment, there was a dispute whether an FIR is to be registered in all cases. Whenever anybody goes, an FIR is to be registered, or it is up to the discretion of the police not to register an FIR. The Supreme Court said that yes, whenever anybody goes to the police station, they must register an FIR if it discloses a cognizable offense. If it does not disclose a cognizable offense, have a preliminary registration and then conduct a preliminary inquiry, because otherwise it has the effect of other side accused, the perpetrated accused against whom allegation is made, it affects his right. So if it discloses a cognizable offense, police must register an FIR. If it does not disclose a cognizable offense, then conduct a preliminary investigation and then register an FIR. And why registration of FIR is necessary? Because it is the earliest in point of time. It prevents manipulation of the facts. It starts the investigation at the earliest possible opportunity. It also, evidence is available at that time. It comes into it debars for manipulation of the evidence. So there it is necessary. But again, whether register, as soon as you register an FIR, there is a cognizable offense, are you required to arrest? It is not. It depends on the facts of this case. So the Supreme Court clearly says registration of FIR is mandatory if cognizable offense is there, but arrest is not mandatory. It depends on the facts of the case, on the depends on the gravity of what has been alleged, whether the police authority says that the evidence can be there, accused will run away, he can affect the evidence, he can tamper with the evidence, and so on and so forth. So as I've been repeatedly saying, understand the principles that will help you in the examination definitely, and that will help you in the longer run for your profession also. See the basic principles. For example, another basic principle, you always run to the 226, a contract is awarded, an evaluation is done, you run to the High Court saying that it is wrongly done. But High Court is not an appellate authority. It just sees the decision-making process is correct or not. It does not substitute its own views. There's a judgment, old judgment at, I think it's serial number 9, serial number 45, regarding Ujjain Municipal Corporation. What is the scope of 226? It refers to a large number of earlier cases. It concises or recapitulates the entire provisions of 226 jurisdiction vis-a-vis contract law. Now, in all contractual matters, there are two parties who has entered into a contract. One party has evaluated the contract, given the contract, but you cannot go to the court and say, no, they have wrongly evaluated the contract. What decision they have taken is wrong on facts. High Court is no one to see. It depends on the parties. But if the process is wrong, if it is mala fide, you are trying to give it for a extraneous consideration and a higher amount to someone who is known, or some other vested interests are there, or somebody who does not fulfill the basic criteria is being given, then High Court's interference comes. But it is very, very rare. Don't think and read that judgment. It will give you the entire law on the scope of judicial review in the contractual matters by the High Courts, and which is very important for you to know. Apart from the examination, you must know, because apart from Supreme Court, in the High Court, most of the cases there's a dispute between the parties, there's a contractual dispute in the parties. So you must know to advise your client whether you will go in a writ jurisdiction, you will go in a suit, or you will avail some other remedy if available. But so far as writ court is concerned, you must be very clear. If there are disputed questions of fact, if there is an assessment made by one of the by the contractor who is to get the work done, the High Court or the Supreme Court will not say that you will re-evaluate, you re-examine the facts of the case, and then according to me this is the correct. The court must come to the conclusion that it is correct. All those things the Supreme Court will not go, especially when they're technical aspect, they're specialized aspect. The Supreme Court has no role to play, or the High Court has no role to play. They have no such special qualifications to assess, and it is ultimately the person who is giving the contract is to know what is his requirement. The court will not evaluate those things. So see the principles which are laid down. Three aspects. Let me conclude saying there are three steps you must read all the case laws. What are the facts? What are the statutory provisions? What are the issues? And what are the ratio laid down? And see in the background of the earlier cases. This will help you immensely in your examination. This will help you immensely in your practice. This will help you in giving the right advice to your client who comes to you and this will help you throughout your career. I think it's very important that we sometimes we close it early. And please understand, don't think that if you write on each cases 10 pages, then you will get more marks. You can write 1 page. We must know while examining the question that you know the law, you have read it. That's all. So mainly because maybe we are trying to close it in 50 minutes time, it's not that we have not explained. We can go on and on. In one case, Mr. Madlapalli can go for 2 days, I can go on for another 1 day. But that's not the purpose of it. The purpose is when you answer any question, apply your mind and just be very crisp. It will help us to evaluate and it will help you to get much more marks. Again, anybody writing 5 pages here and there will not have no patience. All that here perhaps not understood. It's trying to avoid. When you argue in the court and go left, right, don't go to the point. The court also understands that no, you don't have a case or you do not know your brief. If you know the brief, come directly to the point. The court will appreciate and give you the desired relief. Here also, you're not court, but definitely we are going to evaluate what you have written. Be crisp, be to the point, be focused and answer, understand the question. And for that, answering it, read your all 64 cases. Don't think that we have told you these cases you have to be alone to be read. Read them very meticulously. At least I have read most of them twice before coming to you and earlier also. And this has really helped you. Thank you very much. God bless you and wish you all the best. Anything else? Mr. Madlapalli is there. We can join.
Vijay bhai, there was one question which is I read on the screen. One gentleman is asking us whether they should just follow the head notes, but that would be wrong. Head notes is editor's baby. Head notes is not a judgment. Please don't follow head notes. Please read the judgment in its entirety. Somebody asked that question, so I thought I'll just clarify.
I agree that head note is not the judgment. Judgment is what the judge has written. Head note is some editor has prepared it from his own perspective. So read the whole judgment, and in the court also cite the main judgment. Never cite a head note in the court. That's no judge likes, and that is not the judgment. Head note is not a part of the judgment. It's just a easier way to say on your. Suppose you go to the pharmacy, it's written yes, so and so very good pharmacy. It doesn't mean that you have to go to the particular brand of the good. You have to go into it. So that is how it is. So as Madlapalli sir has said rightly that don't go to the head note. It may help you in understanding. You can start it, but read the text of the judgment. That will be our advice. Again, another somebody is saying whether the question paper would be similar to the last year. That you have to see the question paper and answer. I don't think we can answer anything at this stage. And no. And another thing is which judgment we can leave out. No, that is not fair. That is not a fair question to ask. You must read all of it. We have given you some ideas as to how to read, what to read, and how to answer. And definitely you will have choice. Somebody said that yes, you will have a large number of choice. Mr. Madlapalli has told you, and be crisp, be to the point, be focused. There may be more than the earlier. I think 4 or 5. You may have to require a little more, but the question will be very focused, and you will understand it if you have read the judgment carefully. And the head notes are given on the website. The entire judgments are there with the Supreme Court report head notes, and the Supreme Court report head notes really give you a correct perspective. Some other journals does not give, but read the full judgment. That will be very necessary. Somebody is asking about the case law provided in the examination center. I think that we will not be able to advise. That must be there in the details of the examination procedure which has been given. Mr. Goel can say perhaps whether the head notes are given in the examination or not. I have no idea about
Sir, as I have the information, head notes are not given, sir.
All right. So that is the practice. So head notes are not given. Don't proceed on the basis that you will get the head notes in the examination hall. If there's any specific question, we are reading the questions. How many questions should be asked, that you will get only on the question paper. But as in saying, you will have sufficient time if you have read it to answer. You have 3 hours time. Perhaps if you read properly, answer specifically to the focus, you can even finish it before that. Somebody is saying dissenting judgments. So dissenting judgments helps you to understand what is the principle discussed. But the judgment of the court is what the majority has said. If you want to get an extra point, you say there was a dissent. Of course, then we will know that you have read the whole judgment, and maybe you will get an extra point. But the judgment of the court is what majority has said. Somebody said we need to carry head notes of our own. Question mark is there. Said Mr. Goel has informed you are not allowed to carry, and they will not be provided with the head notes. Am I correct, Mr. Goel?
No, sir, head notes are given. So one book will be given of 1,000.
Oh, sorry. Okay, head notes are given.
Yeah, yes, sir.
As per notification, head notes will be provided. Mr. Goel, please do not confuse. All right. So head notes are given. It is made very clear that head notes are given in the examination paper, examination hall, isn't it?
We have to.
Sir, I just want to flag one issue that books are in 2 volumes this time.
Okay. Okay.
Ah.
And
Head
both
notes.
the volumes should be available.
Certainly, sir, we have more than 1,000 copies.
All right. All the candidates will have.
Yeah, definitely, sir. Definitely, sir.
Very good. That's correct.
We'll take care, sir. And all the judgment, not only the head notes, even the entire judgment is available on under the one tab on the website also.
That I have seen that all the judgments are available on
Yes.
the website.
And one more information I just want to share, sir, that we are going to upload all the lectures on our website.
Okay.
It can benefit to those who have who could not attend the classes.
Yes. I think head notes should be of SCR, not SCC, because in the SCR, and they are the official publication of the Supreme Court. All right. Thank you very much, everyone, and wish you all the best.
Thank you, Vijay.
Thank you.
Yeah, thank you.
We'll close.
Yes, sir. You may close, sir.
All right. Thank you.
Thank you.
Thank you.